All right. Well, as folks are joining us now, welcome to the latest webinar from the section of Civil Rights and Social Justice. During the 2017-2018 bar year, our goal is to rapidly respond to government action to matter experts. We encourage you to check out the section website, www.americanbar.org/CRSJ. Our Facebook page, our Twitter handle is @ABA_CRSJ for more news and information and replays of our great programming. If you like our work, we invite you to become a member of the section and collaborate with us on projects you want to develop and offer to our members and the general public. We're thrilled to bring you today's program on FISA Section 702 reauthorization. At the culmination of his first year in office, President Trump signed into law the FISA Amendments Reauthorization Act of 2017, which extends the much debated authority set forth in the FISA Section 702 for another 6 years. Section 702 authorizes the warrantless collection of emails, phone records, and other communications of individuals located outside the United States, including communications with U.S. persons and others within the United States. Although the 2017 Reauthorization Act circumscribes and clarifies the scope of government's Section 702 authority somewhat, it excludes nearly all the broader reform proposals put forward by privacy advocates and other groups. This webinar will provide an overview of Section 702 as well as the reauthorization bill and unpack some of the concerns surrounding the government's use of this warrantless foreign surveillance authority. The two speakers today, myself and Alex Abdo. I am Senior Counsel at the Electronic Privacy Information Center and Chair of the Privacy and Information Protection Committee of the ABA section on Civil Rights and Social Justice. Alex Abdo is a Senior Staff Attorney at the Knight First Amendment Institute at Columbia University and former Senior Staff Attorney at the ACLU. One other thing I'll note before we get started, during today's program, if you're so inclined, you can ask questions of our panelists. There's a question box in your GoToWebinar platform, and we can see those. Should be on the right-hand side there. You'll also be able, after the webinar, to access a handout that we've prepared where you can find more information on this topic by looking through the resources that we've linked. We'll also be sharing a recording of this program with everyone who registered so you can share it throughout your networks. And please feel free to leave us feedback or ask questions on follow-up. So with that, I will kick it over to Alex to get started.
Hi, everyone. Thanks, Alan, for the introduction. Delighted to be here and looking forward to the conversation and to any questions that you have. If I'm unclear at all as we're talking, feel free to, I think you can comment in the chat box or ask a question through the control panel, and we'll try to deal with those as we go along, but we'll set aside some time toward the end too, specifically for questions and answers. So I'm gonna give just a very brief historical lead into the conversation today because it's actually quite difficult to understand foreign intelligence surveillance in this country without understanding the fact that up until the 1970s, there were no statutes on the books regulating the ways in which the intelligence agencies in this country could conduct foreign intelligence or national security surveillance on US soil. It was simply an unregulated power of the government that was exercised, without that regulation for many decades. And perhaps predictably, the lack of regulation of foreign intelligence surveillance on US soil resulted in widespread abuses, abuses that in the late 60s and early 70s began to come to light. And I think one of the memorable pieces of reporting from that era was Seymour Hersh's story in the New York Times disclosing some particular operations of the CIA, which had been famously coined the family jewels of that agency. But on the heels of that report and of other reporting that was going on at the time, Congress got involved and started to investigate the intelligence surveillance of a number of federal agencies in 1975 and 1976 through what were called the Church Committee and the Pike Committee. And the Church Committee ultimately produced over a dozen reports detailing the ways in which the intelligence agencies were formed and functioned, and describing many of the abuses of those agencies over the preceding 30 or 40 years. The real, the one sentence upshot is that the Church Committee discovered widespread surveillance of Americans' communications under the pretext of engaging in surveillance targeted at foreign powers abroad. And the Commission made a number of recommendations, some of which found their way into law. The two that I'll mention briefly are, first, that Congress maintain the Church Committee and the Pike Committees as permanent standing committees of Congress and the House. And that's why we have the Intelligence Committees today. The Church Committee turned into the Senate Select Committee on Intelligence, and the Pike Committee eventually became the House Permanent Select Committee on Intelligence. The second recommendation that the Church Committee made, which set the stage for the surveillance we'll be talking about today, was that foreign intelligence surveillance on US soil be brought under statutory law and judicial oversight. That was the impetus for the drafting and enactment of the Foreign Intelligence Surveillance Act, or FISA, and that's what was in place for 25 years or so before 9/11. And I'll turn it over to Alan now, who will tell us a bit about FISA.
Great, thanks, Alex. As Alex mentioned, when Congress passed the Foreign Intelligence Surveillance Act after the proceedings of the various committees and the rehashing of these surveillance abuses, they put in place a legal system, really an entirely new legal system within the US government to oversee foreign intelligence investigations. And in particular, they created several different structures within the government. So within the judicial branch, they created two courts: a Foreign Intelligence Surveillance Court, which consists of now of 11 district court judges appointed by the Chief Justice of the Supreme Court. They have to have geographic diversity, so they have to come from 7 different circuits, but at least 3 of them have to be near DC, because the actual courthouse is housed within the same federal courthouse here in DC as the federal district court and DC circuit. And so the judges sit in rotation for, I believe, a week at a time and hear applications and orders for both electronic surveillance, which is a key term in the FISA context, and other types of searches, including physical searches and the use of pen registers or business record orders. So the law created the FISA court, FISC. The law also created a court of review, so the Foreign Intelligence Surveillance Court of Review, which consists of 3 judges appointed by the Chief Justice of the Supreme Court. That court has only met on a few occasions over the years of its existence, and I believe its first opinion, which we'll talk about a little bit, was called In Re Sealed case in 2002. So that court only sits when needed. And as I mentioned, the basic structure of FISA is that it prohibits electronic surveillance except in certain circumstances, and brings it under judicial and executive branch oversight. There's a division within the Department of Justice that's had several names over the years, but is now within the DOJ's National Security Division that is responsible for applying that law and for also representing the government and its agencies before the FISA court. So in the traditional FISA context as it existed in the 1980s, following a Second Amendment to the law, you had the FISA court considering applications for either electronic surveillance or physical searches brought by the Department of Justice, and those applications are somewhat similar to warrant applications in that they're based on a showing of probable cause before a judge in an ex parte proceeding, but instead of showing probable cause to believe a crime has been committed and that evidence of a crime will be found at a particular place, the probable cause showing in the FISA context, traditional FISA as they call it, is probable cause that the target of the surveillance is an agent of a foreign power or a foreign power. There's also the requirement now under several different provisions of FISA that we'll talk about that the government minimize data that it collects through this surveillance, so that after it's been collected, it's only used in certain situations. And part of the original structure of the FISA, and it's growing out of the Keith case in the 70s, had to do with the separation between the use of national security, foreign intelligence surveillance authorities with that traditional criminal law enforcement function. This had grown to be called by many referred to as the Fisa Wall, and it was perceived within the Justice Department to impose somewhat rigid restrictions on interactions between criminal law enforcement officials and counterintelligence or intelligence members within, whether it's FBI or CIA. And in fact, shortly after 9/11, there was a change in some of the policies being applied to electronic surveillance under FISA, and the FISA court actually ordered the government to adopt much stricter procedures with respect to these interactions. That was appealed. That was the first case before the FISA Court of Review, and it resulted in a published decision called In Re Sealed case, where the FISA Court of Review ruled that the restrictions that the FISA court had imposed on interactions between intelligence and law enforcement officials were not required by the statute or by the Constitution. So in some sense, brought down the FISA wall is how that can be phrased. And I mentioned beyond the traditional FISA that I just described, there are also a number of other authorities that have been added over the years, including the authority to compel the production of business records. This is referred to as the 215 program that we'll mention in a minute. Also pen registers, orders for communications metadata, as well as other types of searches. So with that, I'll kick it over to Alex to talk about the more recent developments in history.
Great. So that regime of individualized surveillance in the United States predicated on judicial orders began to fall apart after 9/11. And there were really two major shifts in the way in which the government gathered foreign intelligence within the United States on US soil after 9/11. The first, which is not really the subject of our conversation today, but I'll just mention it because it may be of interest, was a transition toward bulk collection. FISA had established the system of individualized surveillance, but increasingly after 9/11, the government began to collect information in bulk. I think the very first bulk collection program that we learned about was disclosed by reporters working with documents turned over by Ed Snowden in 2013, actually 5 years ago, just on the 5th of June, so just 6 days ago. And that was the so-called Section 215 bulk collection program, under which the NSA collected call records of Americans in bulk to house them in a large repository that it would then search for the phone numbers of suspected terrorists abroad. There was a similar program for internet metadata. We know fewer details about that program, and we know it was ended in 2011 for technical reasons, but it was reportedly similar to the call records program, but just involved internet metadata instead. And there was also reportedly a CIA financial records program under which the CIA collected certain financial records in bulk to do the same sort of querying when it had a kind of target in mind. That was the first major shift post 9/11. The second one, which is more relevant to our purposes, was a shift toward warrantless collection of Americans' international communications. FISA had dictated that the government, if it wanted to collect an American's communications for foreign intelligence surveillance purposes, had to go to the FISC or the FISA court to get a court order predicated on probable cause. Not too long after 9/11, the Bush administration's Department of Justice authorized the NSA to ignore that process for judicial review of foreign intelligence surveillance in the United States in a narrow context. If the NSA at that time had a reason to believe that a phone number it wanted to target belonged to a member of Al-Qaeda or somebody associated with Al-Qaeda, then the Department of Justice excused the NSA from complying with the FISA requirement that the government otherwise get a FISA court order. That became known as the Bush administration's warrantless wiretapping program, and it was revealed by the New York Times in 2005. Interestingly, the result of that revelation was not a kind of stern legislative response putting an end to warrantless wiretapping on US soil, but instead the opposite. By 2008, the Department of Justice had helped draft and Congress had enacted what we're here to talk about today, which is the Fisa Amendments Act of 2008, often referred to as Section 702 because it amended, I think it created and later reauthorizations of it amended Section 702 of Fisa. So that was how the Fisa Amendments Act came to be. Now, you may have noticed there's a 3-year gap between 2005, the revelation of the warrantless wiretapping program, and the enactment of the Fisa Amendments Act. And that's in part because there was a stopgap measure in place called the Protect America Act for a couple of years. That act was similar in many respects to Section 702. It had, a couple of salient differences, but we're not going to go into those. For our purposes, the relevant shift was from FISA's regime of individualized and targeted surveillance, or rather, let me just say individualized surveillance, and the Fisa Amendments Act's system of warrantless surveillance. The statute is somewhat complicated, but I'll do my best to distill it. It authorizes the Attorney General and the Director of National Intelligence to submit certifications to the FISA court. And the certifications describe year-long programs of surveillance that the NSA and other agencies want to engage in. And so long as that certification meets the requirements of the statute, which I'll describe in a minute, the FISC is obligated to approve the certification and issue an order that the government can then use during the course of that succeeding year to compel tech companies and telecoms to comply with the surveillance that the government has ascribed to the court. So it's a year-long surveillance orders that the government is obtaining through from the FISA court. And those orders don't list the targets of the government surveillance. They don't constrain the government's purposes except at a very broad level. They just are year-long authorizations of the sort of surveillance the statute authorizes. The two core limitations of that surveillance, the kind of defining features of Section 702 surveillance, are first, that the government must be targeting non-US persons abroad. So it can't target individuals inside the United States. It cannot engage in what is called reverse targeting. It can't target somebody outside the United States with the intent of going after a specific person inside the United States. It has to be targeting a non-US person abroad. That's requirement number one. Requirement number two is that the purpose of the surveillance must be to acquire foreign intelligence information. That phrase is defined by the statute, and it's defined fairly broadly to include not just what you might think, things like terrorism or counterterrorism or proliferation of nuclear weapons. It includes those, but it also includes information relating to the foreign affairs of the United States. So those are the two key requirements of Section 702 when the government is applying for these year-long authorizations, that the program the government is describing has to be focused on non-US persons abroad, and it has to be for the purpose of acquiring foreign intelligence information. Along with the certification, the government has to submit what are called targeting and minimization procedures. The targeting procedures are procedures that are designed to limit the government's selection of targets to those abroad, to non-US persons abroad. And the minimization procedures are the procedures that kick into effect when the government sweeps in Americans' international communications in the course of Section 702 surveillance. The fact that the surveillance has to be limited or targeted at non-US persons abroad doesn't actually mean the government won't be collecting US persons' communications. In fact, the government defended the 702 authority and its predecessor, the stopgap measure that I mentioned earlier, the Protect America Act, in part by pointing to the importance of monitoring communications between a suspected terrorist abroad and someone in the United States. And so it's fairly predictable from the government's perspective that US persons' communications will be swept up in the course of Section 702 surveillance, and the minimization procedures are the procedures in place that are meant to account for that fact. Now, in terms of what the minimization procedures actually require, they require the government in certain circumstances to avoid or limit the retention and use, and in some cases acquisition, of US person information. But there are exceptions to that rule. The two critical ones that appear in the statute itself are for when the evidence in one of the communications concerns a crime, and also if it concerns foreign intelligence information. And so the result of that legal framework is that the government is authorized to engage in year-long warrantless surveillance of Americans' international communications, so long as it is targeting the foreign end of the communication, and so long as the overall purpose of the surveillance is to acquire foreign intelligence information. And I'll kick it back over to Alan, who will describe the programs that we know about that are operating under Section 702.
Great. That's a really good overview of the kind of history leading up to the enactment of 702 in the law. What we've learned more recently, especially following the Snowden disclosures, as Alex mentioned, in 2013, is we've learned more about some of the programs, different programs that operated under these authorities. One thing I'll note at the outset is that there's been some sort of, in the discussions following the Snowden disclosures, there was some sort of resolving of different pieces of the FISA, and there was a lot of discussion about the 215 program, which was about the bulk collection of telephone records that Alex mentioned. That's not part of Section 702. That was under a different authority, and that authority was amended substantially in the USA Freedom Act in 2015, I believe. So the 215 program, which was about bulk collection of telephone call records, call detail records, as they say in the United States, is not part of 702, but it was part of that conversation. But the two programs that we learned about coming from those revelations and what disclosures that were made subsequently are what's called the PRISM program, or the PRISM system, and the upstream program. And so PRISM, the difference between the two is basically where the collection occurs. PRISM is a system through which the government can task surveillance to and basically order a service provider to return certain communications under the 702 authority. So as Alex mentioned, those 702 certifications, once accepted by the FISA court, basically give the Department of Justice, the intelligence community, the legal authority to go to a service provider under those procedures and require their assistance in obtaining electronic communications. And so in an example, you could have the tasking of a particular email address sent to Google, requiring them to provide all communications to or from that email address. So that would be an example of the PRISM program, or similarly to Facebook or to any other provider under that system. What's changed since we first learned about the PRISM program is that there used to be some, or I guess maybe this is more relevant under upstream, but there was a part of that program that was referred to as about collection, where the government would ask for communications not only to or from a particular email address, for example, but also they did not distinguish between those that come to or from an email and those where that email was mentioned, that address was mentioned in the content. So that's what's called about collection, where someone is talking about a selector. So that's mostly relevant to the upstream program. And why it's called upstream is because rather than going to the service providers themselves, with the upstream program, the government's actually going to the provider of internet access to the service provider, the so-called backbone provider, and likely has some technological means of tasking surveillance orders that are directly applied to the data as it is transiting the internet backbone. And so in that situation, if for example, they're tasking an email address, then that email address is resulting in the collection of communications anywhere where that email address appears. So whether it appears in the to from field or in the content field, that's what was happening. Although the about program was shut down several years ago following several orders by the Fisa court, but that's relevant to the law that we're going to discuss. So with that context, that broad overview of the 702 program in general, I'm going to kick it over to Alex and we can talk about some of the criticisms and defenses of the program.
Great. I meant to disclose at the outset, but I'll disclose now since it's, I suppose, most relevant now, that when I was at the ACLU and even now at the Knight First Amendment Institute, I was involved and continue to be involved in litigation challenging the constitutionality of Section 702 surveillance. So you should understand I'm not a disinterested commenter when it comes to the criticisms or defenses of Section 702, but I'll do my best to be neutral in my presentation of those, but take that against the background of my work. So the criticisms of Section 702, there have been three primary criticisms. The first, which I alluded to before, is that Section 702 involves the warrantless surveillance of Americans' international communications. And some, including me when I was at the ACLU and now at the Knight Institute, have argued that as a result, it ends up being an end run around the Fourth Amendment requirement of probable cause and a warrant. That question hasn't been fully litigated in the courts. It has been litigated in a handful of cases. The ones that have addressed it have concluded that a warrant in this context is not required for the acquisition of U.S. persons' international communications based on an exception to the warrant requirement. But that question may very well end up getting teed up at some point in the Supreme Court, and that's one of the major criticisms of 702. And that criticism has been around really since the enactment of the statute. When it was first proposed, one of the amendments that was proposed to what became Section 702 was a requirement that if the government were to use Section 702 to read a U.S. person's emails, for example, it should, before doing so, acquire a warrant. The proposal was actually made by a handful of senators, including then Senator Barack Obama in 2008, but it was rejected, and since then has been a continuing source of debate about the constitutionality of 702, with the basic idea being whether the government gets a free pass in acquiring the communications of U.S. persons based on its targeting of foreigners abroad for foreign intelligence purposes. That's the first primary criticism of Section 702. The second, which is one that Alan just alluded to, is so-called about surveillance. As Alan mentioned, this is the form of surveillance that was taking place as part of the upstream program, where the government would acquire not just communications to or from its targets, but communications that mentioned selectors associated with its targets. The government has variously described this feature of upstream surveillance as a technical necessity, given limitations in its surveillance equipment, and alternatively as an important addition to its authority to be able to acquire communications that are about its targets. Whatever kind of justification the government has offered for it, the result of that form of surveillance was, for some period of time, that the government surveillance equipment was scanning not just the so-called outside of the envelope to see whether the communications that they were acquiring were to or from its targets, but in fact reading the content of the communications to see whether they mentioned targets of the government. Some critics characterize that as equivalent to the Postal Service in implementing an FBI surveillance order, opening up all mail that comes through the Postal Service's processing unit to see whether the mail on the inside mentions a particular target. About surveillance, as Alan mentioned, ended. It was in April 2017 that it ended. It ended in large part for compliance reasons, not because of any determination that it was lawful or unlawful. The government was supposed to segregate communications collected under about authority and not query them for the presence of U.S. person selectors, which is a practice that the government engages in with FISA collected surveillance. but the government had not effectively cordoned off those communications from its querying for US person identifiers. And the FISC told the government, you need to figure out how to comply with this limitation that we've imposed on your surveillance. And last year, the government announced that rather than trying to fix the problems now, it would simply end about surveillance, which it did in April of 2017. It retains the authority to re-implement it, subject to some limitations, which we'll describe a little bit later. But for now, about surveillance is no longer occurring. A related practice that was also the subject of a lot of criticism is this practice of what I just called querying for US person identifiers. It's related to the first concern I mentioned, the warrantless surveillance of US persons, but it's slightly different. The way Section 702 surveillance works now is that when the government acquires communications under the statute, they go into a series of databases that the government maintains that hold these communications. And NSA analysts or other analysts who are authorized to have access to those databases or copies of them query the databases using search terms to see whether there's information relevant to any investigation that they're undertaking. The government has for some time been allowed to use identifiers associated with US persons to query those databases. So for example, it could use the name of a known US person or an email address or a phone number of a known US person to query those databases. Critics pointed out that seemed to, to entrench the manner in which Section 702 constituted an end run around the Fourth Amendment's warrant requirement. Not only could the government knowingly collect US persons' communications without a warrant, but it could, on the back end, actually query the databases specifically to pull those communications up. So that's another source of criticism. As we'll discuss in a few minutes, the Reauthorization Act has limited that somewhat, and we'll discuss the exact contours of that in a minute. I'll mention two other criticisms very quickly. The first of those relates to the secrecy of the Foreign Intelligence Surveillance Court. Since 9/11, with the shift toward broader surveillance programs being overseen by the FISC has been issuing rulings that have had greater and greater precedential effect. They're rulings that opine on the legality or the constitutionality of broad programs of surveillance rather than just targeted surveillance, which is what the FISC was set up to do in 1978 when Fisa was enacted. But there hadn't been for some time a corresponding increase in the transparency of the court. So the court was issuing increasingly significant opinions, opining on the meaning of important constitutional limitations, but those opinions were by and large secret. And some have criticized the process for entrenching what they call secret law, the creation of law that affects the privacy rights of many Americans, but which cannot be seen easily. That has been ameliorated somewhat by recent changes to the statute. In 2015, Congress enacted the USA Freedom Act, which was a precursor to the latest reauthorization. And that requires the government to declassify significant opinions of the FISC, at least those going forward, or so the government argues that applies prospectively. And the Reauthorization Act, as we'll describe in a few minutes, also has some transparency measures. The final one I'll quickly mention has to do with international privacy. It's not a kind of domestic law concern, but an international law concern. One of the key kind of conceptual shifts that Section 702 reflects is a shift away from surveillance based on the identity of the target to surveillance based on the information the target may have. So under traditional surveillance laws, including in the United States and including FISA, before the government could target somebody for surveillance, it had to have a reason to think that that person had either done something wrong or was associated with a foreign government, that the identity of the person justified the surveillance. Under standard surveillance in the United States, you have to have probable cause to believe that somebody has committed a crime or will commit a crime. Under FISA, you have to have probable cause to believe that the individual you wanted to target was an agent of a foreign power. Section 702 shifted away from that kind of conceptual framework toward one in which the information somebody might hold, might be communicating was the sort of target of surveillance. And so earlier when I said that there were two key limitations on Section 702 surveillance, you will have noticed that neither one of those had to do with the identity of the person, except insofar as the person had to be a foreigner abroad. The only other substantive limitation was that the reason that the government was monitoring that person was to collect foreign intelligence information. And international human rights advocates have criticized that approach as justifying the surveillance of virtually any individual abroad, so long as that person was communicating something the government wanted to hear, which could include foreign journalists or foreign human rights activists, because those people might very well be communicating information relating to the foreign affairs of the United States. And they've argued that the surveillance is in part unlawful under international legal constraints for that reason. I think that's probably all we'll say about the kind of international concerns relating to Section 702, but I just wanted to put that out there. So I'll turn it back over to Alan, who'll talk through some of the defenses of Section 702.
Great. And I'll also note, as Alex did, that I've worked on several cases over the years, both a few cases brought on behalf of EPIC, and we've also filed amicus briefs in a number of cases, including in the Clapper case that Alex mentioned. So I'm also not a purely impartial narrator, but trying to provide really an overview here of the defenses that have been offered by the government and others who believe in the propriety of the 702 program itself. I think the core argument that's made here is that this is fundamentally national security or counter-terrorism program, that's its focus, and that in that regard, it's a very important program. The government's emphasized over the last several years, especially after the Snowden disclosures, that the value of the foreign intelligence collected under the 702 authority is incredibly high, that this is the type of information that is significant enough to make it into the president's daily brief and is very sort of an important product of the intelligence community. And for that reason, there's a high justification. I think also structurally, I mentioned before when I was discussing FISA that the central core structure of FISA surrounds this definition of electronic surveillance that Congress provided in that law in the 1970s. And that definition, while very complicated and beyond the immediate scope of this discussion, really did distinguish between surveillance activities that took place within the United States, or rather activities that impacted communications to or from U.S. persons. And there is a part of an argument about 702 that as technology changed and U.S. companies began hosting more communications data, even communications data that are purely foreign in a sense, right? Communications to and from foreign individuals that happen to reside on a U.S. server of a service provider. Those wouldn't have been considered electronic surveillance under traditional FISA, and they argue shouldn't be now considered or shouldn't be restricted in the same way. And they also argue, based on the inherent authorities of the president, that surveillance for national security purposes, especially surveillance targeted outside the United States, should be held to a different standard. So that's really the kind of technological argument and the inherent authority argument, as well as the importance of the data that's collected under this authority. Defenders have also emphasized that unlike some of the other programs that we mentioned, the 702 authority is primarily not used as a bulk authority, in the sense that there is an individual tasking and querying of the data. So under PRISM, the government is looking for communications to and from a specific email address or other tasked selector. And so in that way, it's not, bulk collection of all communications during a particular time or at a particular place that's happening under 702. And similarly, in upstream, now that the about collection has been program has ended, that would again be seen as not so much a bulk collection program. At least that's how it's framed. The other defense is that this program has been approved by all three branches of government. So Congress passed, obviously, the act itself. The executive branch oversees it, and then the FISA court oversees it in a sense that it approves the general guidelines and procedures, and then federal courts, if any criminal cases are brought, have judicial review of the constitutionality of the surveillance specifically. And then the other defense that's offered is that there is a robust system internally within both the Department of Justice and within the intelligence community agencies themselves of oversight, and the Director of National Intelligence of oversight of the program, so that any potential abuses, they argue, would be caught by their internal audits and their internal oversight mechanisms and controls over the systems that store the data that's been collected. So I think with that, we will shift and talk about the latest reauthorization bill itself and really what it did. So Alex, do you want me to start with do you want me to give an overview of the proposals?
Yeah, why don't you do that, and I can do an overview of what was adopted and what was rejected.
Sure. So as Alex mentioned, there was a lot since the original enactment of Section 702. There's been debate over the standard that would apply when querying or when searching within the data that had been collected for U.S. person information, either using a U.S. person's name or an email contact information of a U.S. person. And so when it came to, but the other thing that Congress did when it passed the FISA Amendments Act is it put in a sunset provision that requires Congress to affirmatively reauthorize the law on I believe, a 5 or 6 year basis. And so what happened last year is the law was set to sunset, and Congress was forced then to have a debate and actually affirmatively pass a bill if it wanted to reauthorize the program. So the government proposed that it be reauthorized. I believe at first the proposal was for really a permanent and blanket reauthorization, and that was rejected for a number of reasons, including the political climate last year around surveillance. And so what came out then of the intelligence committees in the House and the Senate were competing proposals, one that was ultimately enacted that Alex will talk about, and the other that was, let's say, more of a middle ground position that would have required warrants for reviewing the content of U.S. person communications in some circumstances, some but not all circumstances, but basically would have had exceptions. And then there was a group of members in the House that proposed, including Representatives Poe and Lofgren, that proposed a more substantial reform of the authority that would have required a warrant across the board, regardless of the purpose of the collection, and also would have required court orders of relevance to do metadata queries with U.S. person identifiers. So those were kind of the proposals that were out there being batted around.
And so just quickly, we'll highlight two primary changes that actually happened with the Reauthorization Act, and just quickly go through a couple others. But you can tell, I think, how detailed the debate has gotten over foreign intelligence surveillance in the last 10 years since the first enactment of the Amendments Act. And so which is why we've taken all this time to set up the frameworks to understand the kind of history of this and the nuance of it. And the modifications that happened with the Reauthorization Act last year kind of reflect that. The two most significant changes are probably these. First is that Congress limited slightly the circumstances in which the FBI can query 702 collected communications for U.S. person identifiers. As I mentioned before, up until this Reauthorization Act, the NSA, but also the FBI, were at liberty to use U.S. person names or identifiers to search through Section 702 collected data. And what we had learned before this reauthorization is that the FBI did that apparently fairly routinely, because it has a set of databases when it's conducting investigations that it frequently searches, even in cases where foreign intelligence is not at issue, or the case doesn't concern anything particularly sensitive or a reason to believe that the communications would be in these databases. Nonetheless, a US person's name might be pulled up as a result of that query. And so in the Reauthorization Act last year, Congress imposed one small constraint on the FBI's US person queries, and that was to prohibit the FBI from engaging, from querying the Section 702 databases when the query is in the context of a predicated criminal investigation not related to national security, and not designed to elicit foreign intelligence information. In that circumstance, the FBI, if it wants to query its Section 702 databases, has to obtain a probable cause order, one of several different types of probable cause orders, before it accesses the contents of that type of query. Interestingly, the way the statute is worded, it appears that the FBI can still conduct the query. It just can't access the contents of any search results before getting a court order in that narrow circumstance. Presumably what that allows the FBI to do is to look at the metadata of the results. So the to and the from and the when of any communications that happen to be pulled up based on the query, and look at those and determine whether, based on what they see, they want to go and get a court order to allow them to access the contents of the search results. So that was one of the more significant changes in the Reauthorization Act. The second is that Congress required the government to inform Congress and give Congress a 30-day review period if and when the NSA wanted to reinstate about collection. And that's significant because about collection has been one of the more controversial aspects of Section 702 surveillance since it was first disclosed post Snowden. And now there is a requirement that the Attorney General and the Director of National Intelligence notify Congress and give Congress 30 days notice if it wants to reinstate about collection. Those are probably the two most significant of the changes in the Reauthorization Act. There are a couple of others that I'll just briefly mention. One is, as I mentioned before, there are a couple of additional transparency provisions in the Act. The USA Freedom Act, which was enacted in 2015, required the government to disclose significant FISC opinions, including those that related to Section 702, to declassify them. The Reauthorization Act of last year adds to that and requires the government to disclose certain statistics relating to Section 702 surveillance, including in particular the volume, if the government is able to estimate it, of U.S. persons who are swept up into that surveillance. Whether we'll ultimately get that data is an open question. The government has maintained for years that it's very difficult to sort out who is or isn't a U.S. person without a careful study of these communications, but there's the possibility anyway that we'll learn a little bit more about how significant effect this statute has for U.S. persons. One thing that we hadn't mentioned, Alan, but I'll mention it now, just to give you a sense of the scope of Section 702. We don't have, I don't think, recent numbers for all of these, but the government has about 100,000 targets of Section 702 surveillance. I think that number, we do have a recent one. I think it's about 114,000 as of a year or two ago. In terms of the number of communications the government acquires under Section 702, the only number that I know of comes from 2011, and that is, in 2011, the government acquired 250 million communications under Section 702, and about, I think, 10% of those, 25 million, were under upstream versus 90% under PRISM surveillance. So notably, absent from the Reauthorization Act, based on the kind of legislative fight that Alan laid out, were a warrant for acquisition of U.S. person communications or a warrant for backdoor searches of U.S. person communications, at least in all circumstances. As I said, they did impose a warrant for backdoor searches in that narrow context, but not for all of them. And advocates had also asked for an outright prohibition on about collection, and Congress didn't enact that. It just enacted a notification requirement. So that's the current lay of the land of Section 702 surveillance and the reauthorization. The only other thing that I'll say is that we're likely to see over the next few years more judicial rulings relating to the constitutionality or legality of this form of surveillance. So far, the Supreme Court has not actually weighed in. In fact, the Supreme Court has never weighed in on the constitutionality of FISA itself, let alone the 2008 amendments to FISA, which codified warrantless surveillance. But that surveillance may yet reach the Supreme Court, and if it does so, it'll reach it probably through one of the criminal cases in which this issue is being litigated. There are a handful of them around the country. When the government uses Section 702 surveillance in the context of a criminal investigation, it has to disclose that fact to criminal defendants, enabling those defendants to challenge the legality of the surveillance. And so one of those cases may make its way up to the Supreme Court. And there are also a couple of civil cases challenging the constitutionality of Section 702 surveillance. And one of those may yet reach a high court for a ruling on the legality of this form of surveillance. Alan, anything to add before we turn it over to questions?
I think we'll open up to questions first, and in case, I have a couple other points in case we have free time there. But if anyone has questions, you can go ahead and type them in. You should be able to find the questions icon in the dashboard. So if anyone has questions, there aren't currently any in the queue, so I can kind of start it off. But if anyone has questions, feel free to add those in there. So one question I guess I have, I'm curious to hear your thoughts about, Alex, is we have now another window, right? We didn't get, the government initially was pushing to remove that sunset provision. Do you have any thoughts on, it's many years away, but thinking forward, will there be another fight at the next sunset? And if so, what will that fight be about?
I hope so. I think there will be. One of the reasons why sunsets are useful is to allow those fights to happen. Without sunsets, these authorities tend to become entirely normalized, and sunsets at least create a necessary bit of friction to allow people to debate, the continuing wisdom of these programs going forward. I imagine the next sunset fight will be similar to this past one. It'll be primarily about searches of, the collection of U.S. person communications and the backdoor searching for those communications. If the government reinstitutes about collection, it may also, we may have another fight about whether Section 702 should encompass about collection. And to the extent that the fight is different than today's, the fight that we had last year, it'll be because we'll have learned more about, maybe it'll be different for two reasons probably. One is because we'll likely have learned more about how Section 702 operates in practice between now and then, and hopefully we'll have learned more because of the transparency requirements. And the fight may also be different because, the further away we as a country get from 9/11, the less of an emergency state we may feel like we're living in, and these authorities, which were, I think perceived to be exceptional when they were enacted, may come to be viewed as anachronistic in the future reauthorization debate and ended. I don't know whether that'll happen. Maybe that's naively optimistic. One other, interesting pressure point, and Alan, maybe you probably spent more time thinking about this than I have, but some of the most promising pressure points for advocates over the last 2 years have been international forums. International courts are increasingly weighing in on the lawfulness of, maybe what I'll call mass surveillance programs, not necessarily bulk, but large scale surveillance programs. And they've been highly critical, and those rulings have affected the extent to which mainly European countries are willing to share data with the US because of the limitations those European countries are under as a result of their charters or their privacy protections. So, advocates have focused on that for the last couple of years, and that may be a point of pressure. Do you have any thoughts on that, Alan, or maybe including the GDPR debate?
Is relevant to GDPR. I think it's more relevant to Privacy Shield. So there's a lot of different international mechanisms that are related to the US and European countries in particular, and the exchange of data between the two. But the current, I would say, cases that are most relevant to this issue are related to transfers actually of data in the commercial sector, not in the government sector, between US and EU data controllers, as they say. They may be part of the same company like Facebook, or they may be different companies transferring data. But there's a particular case that Epic is involved in as an intervener amicus that started in Ireland. That case, referred to as the Schrems case, actually made its way up to the Court of Justice of the European Union one time and resulted in the invalidation of the prior data transfer agreement between the US and the EU called Safe Harbor. Now the US and the EU have renegotiated a new deal, but the case is still alive and is going up on again now to the Court of Justice, the highest court in Europe, on a slightly related question. But the central conflict in the case really is whether the US system offers sufficient protection for the personal data of non-US persons held by a commercial entity like Facebook. Because the argument as it goes, if it does not, is that the transfers are not legal under European law. And if that is the ultimate ruling of the EU based primarily on the upstream program, which I'll explain why in a minute, then that could put substantial pressure on the United States and the US Congress in particular, if companies feel the pain to amend the law. So the reason why upstream, I think, is probably most relevant here is because European data protection law focuses on processing rather than some of the more traditional US conceptions of search and seizure that are always subject to complicated definitions in our Supreme Court cases. And the definition of processing of personal data is much broader. And so the act of sorting data in the upstream program as it transits the internet could be, for example, considered processing in bulk of all communications. And so even if that processing is then used to, downstream narrow down the range of communications, the fact that the processing is happening and the fact that there's no, as Alex mentioned, there's no sort of particularity and no particular evidence against the individual before they're queried if they're outside the United States. So there's a kind of an inherent discrimination in the system between US and non-US persons. And so if that were the ruling of the highest court in Europe, I think that would put substantial pressure on the United States to, change the way the law is structured to provide greater protection or oversight.
Let me just add two quick things, Alan. I think that's fascinating. One is that encryption is going to change this debate over time too. A lot of the controversy surrounding Section 702 really had to do with upstream. There was a focus too on the program as a whole, the extent to which the program, at its core involves a warrantless collection of Americans' international communications. That criticism applies to both PRISM and upstream. But a lot of the flashpoints were around upstream and about collection in particular, and the increasing prevalence of encrypted communications will change that because, as communications are transiting the internet now, they're much more likely to be encrypted than they were 10 years ago. And when they're encrypted, there's only so much information the government can acquire from them, in terms of scanning them as they transit the internet backbone. They can still sometimes collect information about who's communicating with whom, depending on the way the encryption is implemented. But they generally won't be able to collect the content unless they have managed to break the particular form of encryption being used, something that we're not likely to find out about. So that's just one observation. Encryption will change this debate. And the second, this is worth knowing, is that Section 702 is really the tip of the iceberg when it comes to US foreign intelligence surveillance. By far, the more significant legal authority that the government relies on in conducting foreign intelligence surveillance is an executive order, first issued by President Reagan, I think in 1981 or two, called Executive Order 12333. You'll sometimes hear it called 12333. And that executive order concerns surveillance that takes place physically outside the United States. So you can think of traditional wiretapping or signals intelligence that takes place on foreign soil or in undersea cables or the like. And that surveillance, unless it's targeted at a U.S. person, is generally not constrained at all by U.S. statutory law. So just to give you one example of how much broader it is, under 12.333, the government can do a kind of about surveillance on steroids. So under upstream, about surveillance was limited to the use of selectors. You could use a kind of uniquely identifying selector as part of your about surveillance. Under 12.333, the government can conduct straightforward keyword searches. So under Section 702, the government has made very clear you can't use the word bomb as a selector or Osama bin Laden as a selector because that's not uniquely identifying enough. But there's no limitation on the use of those sorts of keywords under Executive Order 12.333. And whether that ends up factoring into the international debate that you were just mentioning, Alan, I think will be really interesting to follow. I haven't seen 12.333 come into those debates yet, although, given how much broader 12.333 is than 702, you would think it would. But it's also worth keeping in mind more generally as we think about, privacy in the digital age. We know far less about what is, beneath the surface. We just have this glimpse of 702, but what lurks beneath, I think, is, much more vast and potentially, invasive.
Yeah, I think that's right. I will note that it did come up, 12.333 did come up in the Schrems proceedings in Ireland, something that we covered somewhat in our briefing. So it is on the record in that case, and it is part of the proceedings. I also found what you were talking about earlier. There is a statistical transparency report that's required now after the Freedom Act that the Director of National Intelligence issued, and it shows number of targets from Section 702 orders. So that's a useful resource. The 2017 number is 129,000. So the scale is huge, as you mentioned. And I think that pretty much covers everything. We don't have any open questions. So with that, I think we will wrap up, and I will thank Alex and everyone for joining us.
Thanks all. Thank you, Alan.
Thanks.